In today's discussion, we delve into a pivotal element of real estate transactions in Texas: objections to the title commitment under the TREC contract. Understanding this process is vital to both the buyer and the seller to facilitate a smooth transaction. Over the weekend, I received a call from a realtor inquiring about a specific exception in her buyer's title commitment. She was unsure about the title company's intention regarding the exception, so I advised her to object to it promptly, ensuring that she met the deadline and allowing time for the title company to clarify its references. Her subsequent question pertained to the potential drawbacks of objecting to a title commitment. She definitely did not want to put her buyer in a bad position. To begin, it's important to comprehend what a title commitment entails. It is a preliminary report issued by a title company outlining the conditions for issuing a title insurance policy. This document details the property's title status, including any defects, exceptions, and encumbrances that could impact ownership, and what is insured under the title policy. Under the TREC contract, buyers are entitled to object to specific issues disclosed in the title commitment. Such objections might involve defects, exceptions, or encumbrances not covered by the standard exceptions listed in the contract in paragraph 6D. Please make sure that your clients understand that paragraph 6D lays out what they can and cannot object to. Objections must be submitted in writing, either within a designated time frame following receipt of the commitment and survey documents, or before closing, whichever is earlier. While the right to object is a crucial safeguard for buyers, it is accompanied by some minor potential drawbacks, which is what the realtor this past weekend was asking me about. When objections are raised, the seller is allotted a 15-day period to address them. If unresolved within this cure period, the buyer may, by notifying the seller within 5 days post-cure period, terminate the contract or waive the objections. Failure to terminate within these 5 days results in an automatic waiver of the objections. This cure period and subsequent notification time extends the closing date if necessary and delays the transaction beyond the original closing date. Beyond just a delay in closing, should the seller be unwilling or unable to rectify the objections, the buyer may opt to terminate the contract, incurring some potential losses in the time and expenses, such as buyer had already paid for the HOA documents or a new survey. While objections to a title commitment offer essential protections for buyers, and while they may also cause a delay in closing, it is important to know that sellers do not have an automatic escape under the contract solely because the buyer objected to the title. In the scenario where the realtor contacted me, objecting to the title afforded the buyer additional time to assess their comfort level with the exceptions, particularly as the seller was unable to rectify the exception in the title commitment. The closing date is automatically extended in the contract for the objection and the cure period. I hope this is helpful information for you all to relay to your clients when the buyer objects to the survey and title documents. Please send any questions you want answered to tipoftheweek@allegiancetitle.com and let us be your resource for results.